Hello everyone, welcome to today's Legal 101. Being a Friday, it's on constitutional and human rights law. Now we're answering this question regarding change of names and the frustration that brings. So for us to be able to understand and answer the question that she asked, I think it is best to give a background. Now, like I already indicated on the Wednesday video, we have Article 35 of the Constitution, which allows for your right to access information, particularly Article 2, which allows for a correction or deletion of misleading information. Let's look at some of the provisions of the Births and Deaths Registration Act and the Births and Deaths Registration Rules. Now, Section 7, subsection 1 and 2 provides that it shall be the duty of every registrar to keep a register of births occurring in and outside Kenya, of course, as pertains to Kenyan citizens. Section 8 provides that a registrar shall not register a birth after the expiration of 6 months from the date of such birth, except upon receiving the written authority of the principal registrar. And this is because registration is supposed to be made within 3 months of the birth of the child. Now, when you notify the registrar of the birth of the child, you have to certify to the correctness of those entries that are made by affixing a mark signing. And that is according to Section 10 of the Act. Under Section 11, when a child is born, a registration of their birth is compulsory. It is the duty of the father and mother of the child, and in default, the occupier of the house in which the child was born, or the person who was present at birth, or the person who's in charge of the child, to notify the registrar. And if, of course, the birth occurs in a prison, a hospital, an orphanage, the barracks, or quarantine station, it is the duty of the officer in charge of that place, that establishment, to notify the registrar. Now, when you come to Section 12, which has since been declared unconstitutional by Justice Mumbi Ngugi in a 2016 judgment, the court provided that the consent of a father or a child born out of wedlock is not required before you include them in the name in the birth register and in the child's birth certificate. And I suppose this is what has led to what we were talking about on Wednesday, where you find that now somebody will just put your name in there as the father of the child, yet there's a biodad who they know is a biodad, but because wanataka kuwekelea, they'll input your name. But of course, we have found a solution for that. If you suspect that it's not your child, you're able to move the court accordingly for your name to be removed from the birth certificate. Moving on, we have Section 14 of the Act, where it is provided that the registrar, where he or she is notified of the birth, then can allow for a period of 2 years where the parents or the guardians of this child can alter the name of the child. It's okay to not have a name. You have 2 years to figure that out. Now, Section 22. Any person who fails to give notice of a birth, who refuses to furnish the prescribed particulars, who willfully gives any false information or particulars for the purpose of registration, shall be guilty of an offense and be liable to a fine not exceeding 500 shillings or to imprisonment for a term not exceeding 6 months or to both. Okay? Section 26. As a Kenyan citizen, you are allowed to inspect the register at a prescribed fee. And this is your constitutional right. Again, we go back to Article 35 on your right to access information that is held by the state. And then finally, we have Section 28, which provides that the principal registrar may prescribe a fee and allow for correction of an error or omission in any register or index. So, for example, if a name is omitted, you have 3 names but one is omitted, or a letter is omitted, or one of the names is misspelled, you can request that the same is rectified. But this correction must be done without erasing the original entry. Okay? Okay, ukipata mtu anasema, oh, okay, we can change it and just, expunge, and nobody will know. You will know. Okay, so we've talked about rectification of errors of birth certificates. Unfortunately, you have to make the payment even if the mistake was not yours, which I believe is a flaw. If it was you who made a mistake and you can own up to it, then it's understood. But you find that sometimes these people are overwhelmed, or they're just and so they don't pay attention. You get back your birth certificate with some errors which are quite minor, and you have to now make the changes. Now, if your birth certificate has 2 names, and then your ID has 3 names, and your passport has 4 names, and your school certificates have, some of them have 2 names, some 3, some 4, etc., you should swear an affidavit where you will be saying, all these names are mine. I answer to all of them. So when you call me this, I will answer, this I will answer, and they all appear in all my documentation. So I just don't want a confusion. There are some offices where you may not be allowed to transact if somebody is questioning whether or not you're the same person because your ID name is different, your school certificate names are different, passport name is different, and what have you. But if you answer to all names, they just swear an affidavit, and it has to be commissioned by a commissioner for oaths like myself. If you don't have if you don't have access to an advocate who is also a commissioner for oaths, just go to your nearest court and say, I have this affidavit, I have signed it, I would like it commissioned, please guide me. They will take you to a magistrate who is then able to commission for you, and they will give you what charges you're supposed to pay, and that will be that. Now, lastly, let's talk about actually changing your name. Say my name is Ayuma. I want to change it to Abondi. But just before we go into that, I just wanted to make an example. If you're a stepdad and you want to make a rectification to somebody's birth certificate, yet they have a biodad in there, you cannot do that. Again, you don't want to erase the identity of this child, and I know it happens, and that is what we have said is called corruption. But this child has a right to know their father, and by the stepdad erasing the biodad, you're denying the child their identity. Certainly, that is not in the best interest of the child. Like we said, when you make these changes, the original entries must be kept in the register. Okay, so that anybody years on, later on, can come back and actually say, okay, I see what happened here. Anything short of that is what we call corruption. Okay, so on the deed poll, a deed poll is a document that you register at the registrar of documents to indicate that you're changing your name from X to Z. Okay, there is a Registration of Documents Act. There's a Registration of Documents Change of Name Regulations, which provide for the procedure and how to go about it. But just to mention a few important facts, and this is some research that I obtained from one of my colleagues. George, if you're watching, thank you. Regulation 4 provides that when you're going to change your name, you must produce your certificate of birth, your birth certificate, because that then shows what your name is, so that you can now tell them what you want your new name to be. And the registrar can reject your application to change your name on the following grounds: if the document is not in the prescribed language, or if it's not accompanied by a certificate of translation, or if there are any blanks or alterations and the person executing the document did not attest to their signature or initial. Now, this is the procedure. You'll fill in the deed poll. It's an actual document, and your advocate will guide you. You will have a witness who has known you for at least 10 years sign a statutory declaration to confirm your former name and your new name, and it will be commissioned. Okay, and if it's a marriage situation, because this happened quite a bit when people get married, you want to add somebody's name to your name, then you provide the marriage certificate. Then you take the document for assessment for stamp duty, and the last time I checked, I believe it was 1,100 shillings. Although let me not say how much it is, but as you can see, it's not a huge figure that you then pay to the exchequer. You present the documents to the registrar of documents. They gazette your intention to change your name in the Kenya Gazette, and the end result is that you get a new ID with a new name. Okay, so you will then have to register for a new ID, but that's easy peasy. Okay, so don't let anybody make you feel like this process is ngumu. It's quite simple. So I hope I have answered your questions and many more. If you have any other questions, please let me know. See you next week. Bye.